S.P. Gupta vs. Union of India, AIR 1982 SC 149. This case is also known as Judge's case or the first Judge's case. In this case, Supreme Court has given one of the longest judgments. Many writ petitions were being filed in different high courts regarding the issue of independence of judiciary. Those cases were transferred to the Supreme Court of India, affecting the independence of judiciary, a basic feature of the Indian Constitution, and controversies concerning the appointment of judges came for determination in this case. Questions of law. One of the issues raised was regarding the validity of central government orders on the non-appointment of two judges and the disclosure of letter of communication between the Law Minister, the Chief Justice of Delhi High Court, and the Chief Justice of India. The court held that upon certain grounds only, the central government decision regarding appointment and transfer could be challenged. The court stated that in an open and effective participatory democracy, the government should be accountable to the public, and the public must have access to information about the functioning of the government. The court held the concept of independence of the judiciary is not limited only to independence from executive pressure or influence, but it is independent from other pressures and prejudices or biasnesses. It has many dimensions, namely fearlessness from other power centers of economic or political, and freedom from prejudices or biasness that have been acquired and nourished by the class to which the judges belong. Article 124 and Article 217 of the Constitution of India deal with the appointment of judges to the Supreme Court and the various high courts. Article 124 of the Indian Constitution, under the heading Establishment and Constitution of Supreme Court, Clause 2 says that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal, after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years, provided that in the case of appointment of judge other than the Chief Justice, the Chief Justice of India shall also be consulted. Article 217 under the heading Appointment and Conditions of the Office of a Judge of a High Court. Clause 1 says, every judge of a High Court shall be appointed by the President by warrant under his hand and seal, after consultation with the Chief Justice of India, the Governor of the State, and in the case of appointment of judge other than the Chief Justice of the High Court, and shall hold office until he attains the age of 62 years. Here, we must remember that the power of the President to appoint judges is purely formal, because in this matter, the President must act on the advice of the Council of Ministers. And because of this, there was an apprehension that the executive may bring politics in the appointment of judges. So, the executive under this article is required to consult persons who are well qualified to give proper advice in matters of appointment of judges. The word consultation came for consideration for the first time in Sankalchand Seth case related to Article 222 before the Supreme Court. In Sankalchand case, Supreme Court said consultation means full and effective consultation. For a full and effective consultation, it is necessary that the three constitutional functionaries must have for its consideration full and identical facts on the basis of which they would be able to take a decision. The President, however, has a right to differ from them and take a contrary view. Consultation does not mean concurrence, and the President is not bound by it. In the present case, the court unanimously agreed with the meaning of the term consultation as explained by the majority in the Sankalchand Seth's case. The meaning of the word consultation in Article 124, Clause 2 is the same as the meaning of the word consultation in Article 212 and Article 222 of the Constitution. This means that the ultimate power to appoint judges vested in the executive, that is the government, from whose dominance and subordination it was actually sought to be protected. The Supreme Court had given up its power of appointment of judges by ruling that the constitution functionaries had merely a consultative role, and power of appointment of judges is solely and exclusively vested in the central government. Justice Bhagawati has, in his judgment, suggested for appointment of a judicial committee for recommending names of persons for appointment as judges of the higher courts, as it is unwise to entrust power in any significant or sensitive area to a single individual, however high or important may be the office which he is occupying. The court held that there were only two grounds on the basis of which the central government decision regarding appointment and transfer can be challenged. Firstly, where there was no full and effective consultation between central government and the appointment authorities, and secondly, the decision of appointment was based on irrelevant grounds. Under these considerations, the court has to decide whether disclosure of a particular document would be contrary to public interest or not. In the present case, it was held that the correspondence or the letter of communication between Law Minister, Chief Justice of Delhi High Court and Chief Justice of India was not protected. Since it dealt with the appointment and transfer of judges, it was held to be one of great importance to public interest. The court recognized that a democratic society cannot keep the activities of the government hidden from the public in order to avoid accountability and criticism. Recognizing a right to know, which seems implicit in the right of the free speech and expression, the court reasoned that whereas society has chosen to accept democracy as its cradle fate, it is elementary that the citizens ought to know what their government is doing. Moreover, the Supreme Court of India recognized the public's right to information as being included in rights to freedom of speech and expression provided under Article 19, Clause 1, Subclause A of the Indian Constitution. Disclosure of information in regard to the functioning of government must be in the rule, and secrecy is an exception. Secrecy justified only where the strictest requirement of public interest demands it. Moreover, the Supreme Court said the approach of the court must be to reduce the area of secrecy as much as possible, consistent with the requirement of public interest, bearing in mind all the time that disclosure also serves an important aspect of public interest. Thank you so much for giving me a valuable time. I hope you liked the video. If you have any doubts, to comment me. I will try in the best possible way to clear your doubts. Do subscribe the channel and hit the bell, as I'll be posting regularly videos like this. Thank you.